When you look at marriage through the eyes of the law, it's a fascinating puzzle. On one hand, it's this incredibly personal promise between two people. But on the other, it can be a hard-nosed negotiated contract, and sometimes it's a fundamental right that people have to literally fight for. So today, we're going to dive into these two very different faces of marriage, all through the real stories of people who took their fights all the way to court.
I mean, it's a question so many of us face, right? You're planning this beautiful life together, dreaming about the future, and at the same time, you're being asked to plan for the possibility of it all coming crashing down. It's this wild dilemma that pits romance right up against reality, and it really forces you to ask, what is a marriage anyway?
And this is the core of it, isn't it? The big debate. For some, a prenup is just smart financial planning. It's about protecting what's yours, making sure your assets are safe, especially if you have kids from a previous marriage. But for others, it feels like you're betting against your own happiness from day one, you know? Like you're building an escape hatch before the ship has even left the port.
Okay, so when does one of these agreements go too far? How do courts decide when a private deal is just plain unfair? Let's jump into a story about one couple that really pulls back the curtain on the pressure and the legal battles that can surround these contracts.
All right, so let's meet Randall and Teresa Shanks. This was the second marriage for both of them. Randall was a successful lawyer, and he had a very clear goal. He wanted to protect his assets for his kids. Teresa, who had actually worked in his office as a paralegal, insisted she wasn't in it for the money. So, right off the bat, you can probably see where this is going. A pretty big imbalance in legal know-how and, well, money.
And this timeline? Whoa, it really shows you what a pressure cooker this whole thing was. Just 10 days before their destination wedding in Jamaica, Randall hands her the prenup. Teresa does talk to a lawyer out of state who basically tells her she's giving up a lot of rights. A few changes are made, but here's the kicker. She signs the final agreement just 2 days before the wedding, without ever getting advice from a lawyer in Iowa. Fast forward 6 years, the marriage is over, and suddenly that prenup is the main event. Teresa argues it shouldn't be enforced, and that forces the court to tackle a huge question. When does a private agreement between two people become so unfair that the law simply won't stand behind it? Luckily for the court in Iowa, they had a sort of 3-point checklist to run this thing through based on state law. They had to ask, 1, did she sign it voluntarily, without being forced? 2, was the agreement unconscionable at the moment she signed it? And 3, did Randall give her a fair and reasonable rundown of his finances?
Okay, that word unconscionable, it's a big one in the legal world, and it's absolutely central to this case. This isn't just about a deal being a little lopsided. To be unconscionable, a deal has to be so oppressive or one-sided, so full of unfair surprise, that it just shocks the conscience. And the courts look at this in 2 different ways. And the way courts look at this is actually pretty smart. They split it in 2, procedural and substantive fairness. Just think of it like the how versus the what. Procedural is all about the signing process. The how. Was there a ton of pressure? Was there deception? Was one person way more powerful? Substantive is about the agreement itself. The what. Are the terms just brutally, unbelievably harsh? So, how did it all shake out? Well, the court sided with Randall on everything. They said an ultimatum, sign this or the wedding is off, isn't legal duress because, hey, she could have just canceled the wedding. They also said the terms weren't substantially unconscionable. Yeah, it was one-sided, but it mostly just kept their finances separate. But the biggest factor was procedure. The court pointed out that Randall told her to get a lawyer. Because she chose not to, the court said it, and these are their words, emasculates her claim. Basically, that one choice destroyed her whole argument.
Okay, so the Shanks case is a huge lesson in how courts see marriage as a private contract, even a really tough one. But that leads to a much, much bigger question. What happens when the fight isn't about the terms of your marriage, but about whether you're even allowed to have one in the first place?
And that brings us to one of the most important civil rights cases in American history. It's the story of a quiet, unassuming couple who just wanted the simple right to live as husband and wife in their own home. This is Mildred Jeter and Richard Loving. They weren't activists, they were just 2 people from a small town in Virginia who grew up together and fell in love. But back then, she was considered colored and he was white. And because the state law in Virginia banned interracial marriage, they had to drive to Washington, D.C. in 1958 just to get a marriage license. Then, they came back home.
Just 5 weeks later, in the middle of the night, police burst into their bedroom and arrested them. They were found guilty. And to understand the mindset they were up against, you just have to hear what the trial judge wrote in his opinion. He gave them a choice: 1 year in jail or leave Virginia and not come back together for 25 years. That single quote says everything about the official prejudice they were facing.
But the Lovings didn't give up. They fought back. And after years of being exiled from their home, their case made it all the way to the U.S. Supreme Court. And in 1967, in a landmark, unanimous decision, the court didn't just strike down Virginia's law. They made a powerful statement for everyone, declaring that the freedom to marry is one of the most basic civil rights we have. And the real-world impact? It was massive. Just look at these numbers. In 1967, the year the decision came down, only about 3% of newlyweds in the U.S. were in an interracial marriage. Fast forward to 2019, and that number jumped all the way up to 19%. That's a huge shift. It shows that when the law changes, society really can too.
Okay, so the Supreme Court says marriage is a fundamental right. Case closed, right? Well, not exactly. Does that mean the government can never put any restrictions on it? That very question popped up just a decade later in another huge case.
And this brings us to Roger Redhale's story. Back in the 70s, Wisconsin had a law that was supposed to make sure parents paid child support. The rule was simple: if you were behind on your payments, you couldn't get a marriage license. Roger Redhale was unemployed and just couldn't afford the $109 a month he owed. So when he tried to get married, the state just said, nope, you can't. So the Supreme Court takes a look at this Wisconsin law and basically just follows the logic. Step 1, what's the goal? To collect child support. Okay, fair enough, that's a good goal. Step 2, how are they doing it? By blocking people from getting married. Step 3, does that even make sense? And the court said, absolutely not. Preventing someone from getting married doesn't magically make money appear. In fact, it might make it harder to pay, especially if their new spouse has a job. So the court ruled the law was unconstitutional. It was a clumsy tool that got in the way of a fundamental right.
But here's the tragic irony, the part of the story that really sticks with you. Roger Redhale won. He changed the law for everybody. But for him, personally, the struggle wasn't over. 40 years later, because of interest and other fees, his child support debt had exploded to over $63,000. And that debt was still stopping him from marrying his fiancée because he was afraid she'd get stuck with it. A huge legal victory that changed the law of the land, but it didn't solve his problem at all.
So after looking at these stories, where does that leave us? We've basically seen marriage through two completely different legal lenses, one where it's a private deal and one where it's a public right. And this slide really puts those two sides of the coin right next to each other. In the Shanks case, we see that courts give people a lot of freedom to write their own rules, and they'll enforce even a really one-sided deal as long as the process was fair. But then you have Loving and Zablocki, which show there's a line. The government can't create laws that put up a huge wall blocking people's fundamental right to get married in the first place.
All right, so let's boil this all down. What have we really learned? First off, prenups are serious contracts, but they're not bulletproof. Courts will put them under a microscope to check for fairness. Second, the freedom to marry who you love is a core constitutional right, period. Third, states can have rules about marriage, sure, but they can't just slam the door on entire groups of people. And finally, at the end of the day, it's all one big balancing act between our freedom to make our own deals and the government's duty to protect a fundamental right.
And all of this leaves us with one big final question for the future. As our lives get more complicated, financially and otherwise, and as our idea of family continues to evolve, which side of marriage are we going to lean on more? Will it become more of a private, customized contract that individuals design for themselves? Or will we double down on the idea that it's a public right, an institution that the state has a duty to protect for everyone? That's a question the law is going to be wrestling with for a long, long time.